capable of sponsoring you for a visa. So there's a period where you really aren't able to have work authorization. And the law recognizes that. And what the government has done is they've defined the terms of the business visitor visa to include the activities that a person engages in when you're setting up a business. So right now you guys are here on visitor visas, I'm sure. And for what may seem like an uncomfortably long time, you kind of have to stay on business visitor visas. So if you're from a visa waiver country, when you're coming to negotiate contracts, you're coming to meet with your attorneys to set up your companies, you're doing all the negotiations for leases, hiring people, all the things that go into building a business are permitted as a business visitor. But then there's going to be a point where you transition from business visitor to working. And that point is determined by a few things, in part what the requirements of the visa are. So when you're first coming over, okay, so when you first come over, you're going to launch your business. So you come on a business visitor visa. If you're under a visa waiver, you can stay for 90 days at a time. You can't extend it. You have to leave and come back. So as you're leaving and coming back, eventually immigration is going to say, you're out for a week, you're back for 90 days, you're out for a week, you're back for 90 days. It sounds like you're not really a visitor. What are you doing? And if you've got evidence about the business activities you're going to be engaging in, the meetings, and the fact that you're cognizant that you'll need a work visa at some point, but that you're investing in building a business, that is enough to keep going back and forth, in spite of the fact that there will be some scrutiny. If you're not from a visa waiver country, you can get a B1, B2 visa, and the same terms apply, except you can stay 180 days at a time. And if you need to, if you're engaging in software development and it's just things are going on and on, you can extend for an additional 180 days freely. For both of them, eventually, the questions will become so pressing in the minds of the immigration agents that you'll just have to consider, changing to another visa. And when that point comes, there are two really good options for entrepreneurs. The first is a treaty investor visa, and it's for companies that are majority owned by individuals or companies that have nationalities of certain treaties that we have in place with countries around the world. And we have these treaties in place with almost all of our major trading partners, with some exceptions. And you guys can come up and ask me if you guys have questions about whether you're going to qualify. But assuming the treaty's in place, then we have to show that the company is owned by nationals of that treaty, at least 50%. 51% is really the magic number. You can do it at 50%, but it makes it tricky. And that the investment is substantial. So depending on the type of business, sometimes there's not that much capital required to start the business. And the definition of substantial is how much does it take to start this particular business? The rule of thumb about what is considered to be the right value amount is around 100,000, 150,000. But really the way they define it is, if this is going to be a business that's going to make money, you're going to hire people. So it's not a marginal business. And really to launch it, it only costs $75,000. Then when you've gotten a high enough proportion of that investment in place so that you're ready to launch, at this point, typically when we draft the cases, we say, we define the business as requiring $75,000, and then magically $75,000 has been invested. But you show you've got the amount needed to launch the business, and then you show it. You put together a case that's filed with the consulate that has jurisdiction of your homes abroad. And you file the evidence of the investment, the evidence of the ownership, a strong business plan with 5 years of projections. And they look at the whole thing, and if they believe that the business is more than marginal, so it's going to grow, and that the investment is essentially completed so that you're ready to launch, they'll give you an E2 visa, which is good for anywhere from 1 to 5 years, depending on the country. Typically, it's 5. And then each time you come in, you can stay for two full years in each entry, and you can only work for your country, for your company. The dependent visa on an E2 is also the E2, so spouses of E2 visa holders can get work authorization. So it's an excellent visa, and it remains good while all of those terms exist. So So as you'll see later, if you're going to sell off equity in your company, then, and you're on an E2 visa, you have to consider your immigration options, because if the ownership dips below 50%, then you lose automatically and immediately your E2 eligibility. So the second visa that we use for entrepreneurs typically,
Let me fix it.
there we go. Better?
I fixed it.
Yeah, you're brilliant. Is an L1 visa. An L1 visa is an intra-company transfer. So for people who've been working essentially for the same company, but outside the United States for at least a year, and then are coming to a related company, which means either parent, subsidiary, branch, or affiliate. So there has to be joint ownership somehow, and you can draw that connection in lots of different ways. But joint ownership and control between the foreign company and the US company, transferring here is possible on an L1 visa. We actually have a particular category of L1 visa for new companies. So generally for an L visa, they're really careful to check whether the individual has either specialized knowledge or is going to be working as an executive. But for the new office, if you show a good business plan, you've got a commercial lease, and there's going to be, or at least the projection for hiring, it's fairly easy to get a new office L. The problem is that the new office Ls are only good for 1 year, and at the end of the year, then they're very hard on whether you built the business to the point where it really supports the visa. So L1s are certainly possible, but in general, I steer people towards E2 visas. They just seem to be more reliable, and it's just kind of a more favorable view currently of E2 visas. On L1 visas, the L2 visa, which is the dependent visa, also allows for work authorization of your spouse. So, you come on a visitor visa. So, you come on a visitor visa to set up the business and launch it. Once you're at the point where you're working, and another key thing is where you're going to draw money from U.S. sources, you need to switch off the visitor visa onto an E2 or an L1 or the typical routes. And then you run your business, you build your business, you're working just for your business with E2 or L1, and eventually you'll start thinking exit strategy and you'll want to sell equity, or you'll need to sell equity for whatever the next growth stage is. And for both L1s and E2s, if you sell equities so that either the relationship between the two companies for the L1 is broken, or the treaty ownership of the E2 drops below 50%, if either of those things are going to happen, then you need to switch on to a traditional work visa, just a professional worker visa, where you're going to be sponsored by a company, which now is no longer going to be controlled by you entirely. So immigration is less suspicious of using that company to sponsor yourself for a visa. Once you're going to have investment and you're not going to have 50% ownership, it's pretty safe and reliable to be able to get either an H-1B visa, which is a classic professional worker visa, or for Australians, an E3 visa. And they're both legally designed for specialty occupations, which means positions that typically require a particular bachelor's degree. So if you're running a company as CEO, president, that's a position that does require a degree typically. But then the applicant also has to have a degree. So for people who, and it has to be a degree or the equivalent. So either a 4-year bachelor's degree abroad, or qualifying experience that's the equivalent to a bachelor's degree. And the way they do that calculation is for every year of the university, below 4 years of the university that a person's missing, you have to show 3 years of professional level experience. So conceivably, a young entrepreneur who hasn't been to college, who hasn't been working in the profession for 12 years, might not qualify for the visa. So it's possible. But if the thing runs its course in the way it really works, works, going to the H-1B when the investment's going to really come is ideal. Here's one thing. There are only a limited number of H-1B visas, so there's a period during the year where sometimes they're not available. So if you're going to dilute the business and the event is going to occur, in March, April, May, over the summer of a particular year, it's quite possible that there won't be a visa available. So you'll have to think creatively about other options or do things in advance. And there are ways to push that forward so you can time it with the sale of the equity in a company.
You're right on 4 more minutes.
Okay. I think I'm at the end of my presentation. Does anybody have any questions? Yeah.
Just in relation to the L2 visa, the spouse.
Yeah.
Do you actually have to be married, or do you just prove that you are kind of in a relationship?
You actually have to be legally married.
Jeff, will you repeat the question so
sure.
people can hear it?
The question was, to qualify for an L2 visa, does your partner actually have to be your legal spouse? And for U.S. immigration law, there has to be a legal marriage. There is a visa for domestic partners. If you've lived together and you've got a provable relationship, they qualify for B2 visas, which is just a visitor visa, but they issue them so that each time they enter, they can stay for up to a year, and they don't get questioned about what their purpose is. Their purpose is to live with you, but they can't work. Yeah?
What's the story with Canadian passports? I've got dual nationality.
Canadians don't need visas, so for B1, B2, it's essentially the same. You're admitted for 90 days. Sometimes they don't even issue I-94s, but the presumption is that your maximum stay is 90 days, not extendable while you're in the U.S. For E2s, it's the exception for Canadians. You actually do have to go to a U.S. consulate, prove the investment, the ownership, the viability of the business, and they issue you an E2 visa. It's the one exception for Canadians. L1s, you can just apply directly to immigration, get an approval notice, no visa required, and just use that for travel. Or, you can just go to the border, prove the connection, and get an L1 visa right there. H-1B visas are kind of like H-1Bs. You have to have pre-approval through immigration here, but no visa required, and just travel with your passport and approval from immigration here.
It sounds like L1 the way to go.
Yeah, L1's good for 1 year. The thing I don't like about L1s is that pretty much 6 months after you've got the visa, if it's only good for 1 year, you have to start thinking about how you're going to extend your visa. And you're going to wind up probably, unless you've got maybe 8 or 10 employees at that point, you can show that you're really doing executive duties on a day-to-day basis and not, dealing with facilities, dealing with marketing, doing the whole thing, which entrepreneurs do. Unless you can really grow quickly, it's hard to get an extension beyond that first year. So for companies that are just, really setting up major operations, I love to do L1s. It kind of lays the foundation for the next stage of a green card. But for smaller operations where it's uncertain what the success will be, E2s are good because in general, for 5, up to 7 years, you'll never have to worry about it.
Any other questions? What happens if an entrepreneur chooses to shut down their foreign business? How does that impact their visa status?
That's a good question. This is a planning issue here, and also a reason that L1s can be tough. Because for an L1 to remain viable, there has to be a foreign entity to which you or the L1 visa holder could conceivably be transferred. So if the operations abroad stop doing business, even though they remain a legal entity, but if they stop operating, which is shown by client contracts and bank statements, lease photos, if they stop operations, then you lose the L visa. And in that case, an E2 is also a better choice.
Great. Thank you so much. I think we're at time, so we'll move on to the next speaker. Thank you so much.
Thank you.
Good morning. My name is Kathy Weber Gardner, and I'm an attorney, a corporate lawyer, an attorney with a firm called Montgomery Pacific. For many years, I practiced with an enormous multinational law firm called Orrick Harrington, and was a partner there, and focused my practice on working with companies from all over the world, as well as the U.S. So right now, I have a corporate boutique, which means a small firm that's just very focused on working with tech and life science companies from outside the U.S. who are coming to Silicon Valley to establish their business. It'd be great for me, and I think for the other panelists, just to have a sense of generally where people are from. So if anyone from Sweden is here, will you raise your hand? Okay, one. Okay. And what about Australia or New Zealand? Yeah, okay. Asia? What country? Japan. And sorry, someone back there. What country? Taiwan. And then if I didn't cover your country, can you just yell out?
China.
China, thank you. Okay. Did I miss anyone? Okay. Great. So there's a reason that we did this in the order that we did, because the first thing on your mind is going to be immigration issues when you come here, right? So that's why Jeff made his great presentation first. And typically the second thought is, well, okay, how do I get my company set up? And do I really need to have a company here, or can I just use the one that I have back home? And Jeff gave you some great reasons why, yeah, you really need to have a company established in the United States. So questions that I get all the time when I'm starting to work with a new client from outside the U.S., what kind of corporation do I need? And a very simple answer is that if you are hoping and considering that you're going to be eventually backed by venture capitalists, that you're going to raise funds, you're going to establish what we call in the United States a C corporation. And typically that corporation will not be a California corporation, but rather it will be a Delaware corporation. Has anyone here heard about the state of Delaware and why I'm talking about it right now? One person. Okay. So Delaware, tiny little state on the eastern coast of the United States, about 50 years ago decided that it wanted to be a powerhouse in the United States as far as corporate law is concerned. And it succeeded in spades, such that a venture capitalist who's talking to you and says we want to invest in you is going to expect that you are actually incorporated in Delaware. Nope, you don't ever have to go there. It's a lovely state. I've been there. It's really nice. But you don't have to go there. But it's typically necessary for you to actually be incorporated there. And then assuming you want to actually do business here in California, we will qualify you in California. Happy to talk more if that's not your particular scenario, but for most of you, that's what it will be. Now, once you make that decision that you're going to incorporate in Delaware, what do you need to do? The good news is Delaware is super efficient, and there are some very standard documents that you will need to get the company up and running. Carrie already mentioned one. The bank will need, and you will need to get started, a Delaware certificate of incorporation. It takes about a day, super easy. After that, we put together for you something called your bylaws. Other countries call it like a charter. Essentially, it's the rules of the road by which your company is going to operate. The board has to meet, has to make some decisions about who your bank is, who your accountant is, who's going to be the officers, so that's another document. None of this takes very long or is too intricate. Finally, you'll have a stock purchase agreement so that either, let's say for example, the Japanese company has its headquarters in Japan, it's established there, this is going to be its U.S. outpost. The Japanese company would own stock in the U.S. company, and the U.S. company would become the Japanese company's wholly owned subsidiary. That's not the case if you're three great founders and an idea, but you don't have an existing company back home, then we would just set up the company for you, and those 3 founders would become the stockholders in this new company. So after we get you started, you might say, enough with the lawyers, I want to take a lawyer break for now, and that's perfectly understandable, but you may have some other things you want to do. If you if you don't have a parent back home, and you're just 3 founders setting up the company here, sooner or later you may want to set up a stock option plan, and we would do that for you. You may have, and we hope you would have, some commercial agreements with your new customers. Lawyers handle that for you. Maybe you want to enter into a joint venture with a partner here. We do that too. And then, of course, we handle all your financing matters. So to the extent you are going to angels and raising debt or equity, we would help you with that. To the extent you are going to venture capitalists and raising equity, we help you with that. And it's a good thing to mention that, just as Carrie outlined for you, all the amazing things that Silicon Valley Bank can do for you, and it's truly, it's like getting into an exclusive club. It's really amazing, and I have nothing to do with Silicon Valley Bank. I just have practiced here a long time, and I know that. But on top of that, any good corporate lawyer should be able to help you make introductions to angels, make introductions to venture capitalists, know who the right tax and accounting firm is. So that's not something we can charge for or would charge for. It's just something that we do as providing a service to you. So that's part of what we provide. Vicki, how are we in terms of time?
You've got about 8 minutes left,
Okay.
including questions.
Okay, so
go
I'll
to
just-
questions, whenever you're ready.
Right. Has anyone here heard about something called a flip-up? Okay, so let's say you've got the parent back in Australia, and you've been doing business, you're doing great, coming here, you're setting up the subsidiary here, and then your business starts really growing here in the United States, and it starts to dwarf what's going on in Australia. You might have great R&D back there, you might have a good subset of clients there, but what starts really happening is all in the United States. And you also want to raise money here. You may decide that you want to do what's called a flip-up, which is kind of like what it sounds. You're turning the U.S. subsidiary into the parent, and then probably you would be keeping the Australian parent as a subsidiary. And the reason that you do that is primarily because you're seeking U.S. money. And it's not that U.S. investors aren't comfortable and sophisticated enough to invest in a foreign company, because very often they are, but it's just that it's easier. And it can be less complicated, and it can be just easier for you to raise money from a wider swath of venture capitalists if you actually are raising money via the U.S. parent. And again, I'm happy to talk about that with any particular questions. And that being said, I'm happy to answer any questions after I put my glasses on. Okay, now I can see you. And please say where you're from, too. Yeah, I can hear you. You have a fine American accent. Yes, that's right. And this,
Kathy, could you repeat the
Oh, yes.
question if you
Pardon me,
got
yeah.
it? Yeah.
all right, the question is, could I talk a little bit about why companies might want to establish themselves in the Cayman Islands? As a general proposition, Cayman Islands are used more as a conduit between, for example, a U.S. company that's investing in China that might established sort of an in-between company in the Cayman Islands. It's very tax-driven. It's very tax-driven. It's less used when companies are coming here. But there could be tax reasons that you want to stick a Cayman Island entity between, you know, let's say the Swedish parent and the U.S. subsidiary. It's very, very tax-driven. But it's commonly used, you're right. And I heard it's very beautiful if you want to go there too. So yeah. Yes?
Can you elaborate on incorporating the difference between Delaware and Nevada? Because I know Delaware is the primary spot.
Yeah.
So could you elaborate on the differences?
I kind
or
of
advantages?
hate that Nevada question. But and wait, where are you from first?
Here.
Nevada? No.
No, here.
Here. Okay. Sorry if I insulted you.
Not that maybe. Other
You
people
know,
might
it's,
wanna
I don't know, it's this weird, funny thing about Nevada that people, there may be some reasons, for tax reasons to incorporate there, but in terms of the kind of companies that are in this room that want to, you know, that want to go out and raise money and get their business going, I don't know about Nevada. I think you need to be in Delaware, unless you've got a really good reason not to be. So. There must be some tax advantages, but I think the Delaware draw just trumps it. Yes,
You know,
sir.
I'm from Australia.
Mhm.
What are some of, or can you perhaps point us out some of the costs that we might need to be aware of, some of the hidden costs perhaps?
Yeah, in terms of incorporating?
In terms of incorporating, so we have an Australian company, we want to set up a
Yeah.
US subsidiary.
Ballpark, $4,000 to $6,000 for legal fees and incorporation fees in Delaware and California. Because as I mentioned, you need to be qualified here. Yeah, just roughly. No other questions? Yes?
Kathy, I have one question around Delaware. I mean,
Yeah.
what's the benefit, extra benefit of Delaware versus any other?
Sure, okay.
Did everyone hear that question?
Oh, and let me repeat it, thank you. The question is, why Delaware, and what makes it just so special that you need to go to the effort of incorporating there? Delaware, as I mentioned, 40 or 50 years ago, really worked hard to establish this very elaborate system of laws that are very company-friendly. So what that means is, Delaware assumes you're an adult and that you can think through how you want your company established and how you want to enter into contracts. And as long as you do things in a business-like way, Delaware's going to honor that. Delaware doesn't impose a lot of its own views on the way the way people who are setting up a business interact with each other. Delaware has this amazing court system that's just for business issues, and is, you know, the judges in that court system are some of the best legal minds in the country. And so if there's any issue among Delaware corporations, lawyers all across the U.S. look to Delaware and Delaware law as to like how something should be resolved. So it's said about making itself as the much more sophisticated state in terms of business law than any other state. And then, you know, some of it gets to be a bit of a following the herd mentality that every company that goes public says, okay, we must be a Delaware company. And then people say, well, I don't really want to acquire a company unless it's Delaware because I know Delaware, I like Delaware. No surprises in Delaware, I want to acquire a Delaware company. And so it's just fed on itself.
Excuse me, Kathy, could you also elaborate if you do incorporate in Delaware, would you still have to do some registration in California for those companies? who
Yes, I'm
actually
sorry, I had mentioned that. You have to be qualified to do business here or wherever else you decide to be in the United States. So you have to qualify here, yeah.
Is this working? I just had another question regarding payroll tax. What are there different rates of payroll tax in the US that we need to be aware of? How does payroll tax work in the US?
Sadly, I'm not a tax lawyer.
Yeah.
So I do not know the answer to that question, I'm sorry.
The payroll tax is a federal tax.
Okay, here we go.
Go ahead.
Oh,
Okay, so I'm not a tax lawyer either. As an HR manager, just know that there's deductions for state, federal, FICA, SDI, which is state disability insurance. You also, for equal amount that you deduct from the employee's paycheck, you need to also put away into the state and federal equally. So there's usually a 1-to-1 ratio. So you don't worry about what tax bracket your employees are in, whether they're at the CEO level or, you know, a janitor or receptionist. They will do their own tax accounting, but you'll have a specific rate that you have to give into state and federal for their, I think it's, I don't know what OADI stands for, but there's definitely the federal insurances, and then there's the state disability insurance.
Thank you.
That's, Kathy, we're right at time for you, but I just have one question.
Yes.
If you're doing business in California, you have to, you know, be registered here. What constitutes doing business in? I mean, I could have customers all over North America.
Right, and that gets a little bit tricky, but you can assume, sort of as a rule of thumb, that if your U.S. headquarters are here, if this is where the bulk of your employees are, if this is your base, you're doing business in California and you need to be qualified here. Now, let's say that you set up a sales office in Chicago and hire a couple people there. You're probably doing business in Illinois too, and that we would need to qualify you to do business there as well. And it depends, you know, here's a great thing that Vicki didn't ask, but is very confusing to people from outside the US. One time I got a call from an Australian company, asked me all these questions. We spent about an hour on the phone, and he concluded the call by saying, okay, well, so I'm going to set up my company in Texas, and I'm never going to do anything in California. I was like, whoa. I already explained to you how Delaware's a little bit odd, and part of that oddity is that corporate lawyers from all over the United States can advise us to Delaware law. But if you're going to be doing business completely outside of California, you need a lawyer who's qualified in the particular state. So it really varies state to state. If you're going to be doing business here, a California lawyer can help you. If you're going to have nothing to do with California, you need to get counsel in that particular state.
Thanks, Kathy.
Next up is Sudi.
I'm the shortest in the group, so I have to lower the microphone. Good morning. My name is Sudi Tronson, and I'm a founder of a boutique intellectual property firm here in Silicon Valley. Before I get started, I'm going to first see if I can get this thing. Is it working okay?
Yep.
So what we're going to talk about a little bit today, and as I'm sure you all appreciate, IP law is very complex. Some of the major differentiators between IP practice and what we have heard some of the other panelists is that it's a federal practice. It is not unique. It's not under state law. So we can actually file for patents and prosecute patents and so forth, for all of the United States, not just for California. However, for working, let's say if you want to do something in England, if there's a company that is going abroad or is coming from abroad to U.S., we have to associate with what we call a foreign associate, which is a local counsel abroad. So there's always that interplay and relationship. So a little bit more also in terms of differences is that when we have to practice IP law, especially patent law, is that in addition to the practice of law and being a lawyer and being knowledgeable in the rules and regulations, we also have to have a technical background. And for that, most of us have actually practiced as engineers or scientists for a few years. Myself, I have a graduate degree in engineering, worked in the pharmaceutical industry, worked in semiconductors, and then went to law school after 10 years and have been practicing with a corporate level at like Hewlett-Packard, in-house at a startup that we sold to a Japanese company, and at 2 major law firms before starting my own practice. So I've aged myself, so let's not question that much. So we're going to go very briefly over some complex issues, and then I'll be more than happy to address any questions you have. So what is IP? Why is it that it's important for those of us that we consider it important? Some of the recent changes that you may want to be aware of with respect to patent changes, which have just went into effect on the 26th of this month, and the strategies involved. So many of you have actually interacted with me before. You asked whether you should file for a patent application. you don't want to file for a patent application just to have it on a wall as a plaque, although there are some people who take great pleasure in that. However, what is of importance, there's a value involved. Just like anything else that you do, you want to derive money from that. It's an asset. That's what we call it intellectual property. It's just that it's not something that is physical. Later on, if you have a software, you have a product, whatever it might be, it might manifest itself in a physical, what we call a physical embodiment, but it's really the product of your mind and your intellect. But let's assume that you do have an IP. Why does it make it important? When do you have to decide whether you should file or not? The point is that if it's like anything else, if it has any value, and that is your value proposition to an investor, people are going to want it, and you will need to protect it. That is the time that you decide whether to be successful in your business. Do you need to protect it and exclude other people from taking away your property? Or is it a first-to-market decision, or is it purely a marketing decision? So those are some of the factors that you have to consider when you decide whether you should file for a patent. And by the way, intellectual property is a much broader scope than just patents, but today we're just going to concentrate on patents a little bit more. It involves trade secrets, things that you have to keep to yourself, and I know a lot of you work in shared spaces, so you have to be particularly aware and conscious of that when it comes to protecting your ideas, because you can lose it if you speak too early. It's kind of like the whole commercial. Now, some of the things you need to remember, and why is it important, why are we talking about US versus some other country, is that patent, when you get a patent issued to you, it's very jurisdictional. The US patent is only enforceable and good in the US, one in China is only good in China, and vice versa. So it is important that you kind of keep those considerations in mind. However, a lot of you, as I have spoken to you before, what you have are software-driven patents, or things that involve perhaps hosting services or processes abroad. And it's important to keep in mind that the drafting of your applications are crucial, because you can cover your protections, your intellectual property, if somebody is doing work in the US, but let's say they're going to do some of the server processing abroad. How can you draft your languages so that you can at least have your US protection? There's a great example, a case example is RIM, Research in Motion versus BlackBerry, that was very crucial and critical in this subject. So some of the things that you need to think about is what are some of the other considerations and requirements for a patent. We talked about technical background. Now, what you want to remember is that the whole idea is that to get a patent, to apply for a patent, to begin with, it has to be new. So patent attorneys spend a considerable amount of time in understanding your ideas, because that's the whole purpose. How is it different? Otherwise, what's the point of filing? Because you're never going to get a patent issued to you for that idea. So again, for coming to US, you're going to be considering you have a product, you have an idea, and you want to decide where you want to file it, which part of the world, because it is very expensive to do that. So there's several considerations, numerous considerations that you have to keep in mind. Where are you going to do business? Where are your competitors? Where are your market? Where are you going to be successful in making your company go worldwide and be successful? So there's a host of considerations and factors that you have to keep in mind when you make those decisions. Now you might ask, why US? You're coming here to do business. You might have filed something abroad and your home countries, and why do you have to worry about the US? Money. It's a property, just like anything else. You're doing it for money. It's not for a greater purpose. So there is a lot, and as you can see, some of these slides I'll go very quickly because it's all intended to demonstrate the value of the IP that you have. There's quite a number of companies that are not necessarily, they didn't succeed in their business approach, but they have sold their IP for lots of money, zillions of dollars. So again, it's something that you can leverage, not just in making your own business successful, but also in case that the business is not a going concern a few years down the line. And this is happening both for companies that are actually making and using their own ideas into products or services, as well as those that are companies that are going to be holding and purchasing IPs of other companies, and they're making a lot of transactions and perhaps even litigations. So there's a lot of, again, it all comes down to the value proposition. This is a complex slide, again, just trying to show you how much some of these companies, most of which you have probably heard about, get involved in the business of patents. Who is suing who? Why? You know, are they cross-licensing with one another? Are they going to be leveraging each other's IP? Or do they? Is one suing one and the other one is responding to the lawsuit, which is usually going to be a two-way communication in the litigation. So it is again a very complex area for litigation. And again, for money. And these are some of the awards. It's not unique to software and like Google type companies. It goes to medical devices, pharmaceuticals, and a lot of software and service-oriented companies. Other reasons for filing is you do it both for offensive as well as defensive purposes. Again, as we mentioned, you may fail. I mean, the company may fail as a business. Nobody's fault, but things happen, and you can go ahead and take advantage of that. As well as a defensive. Most of it, you've all, I'm sure, heard of non-disclosure or non-use and non-use agreements. A lot of companies like Google, for example, they have policies that they will not sign NDAs. VCs most of the times will not sign an NDA. And sometimes they make you actually sign something, these major companies, that say you're not going to be telling this major company anything that is a secret. So by protecting your idea, what is the best proof is that you have filed your patent application in the United States, for example, before you discuss your ideas with any potential investors and partners in terms of companies.
Sudi, we're just probably right on to Q&A time. Yeah.
Okay. So there's a lot of questions, a lot of times about doing a provisional application. One of the things that I just want to caution you about provisionals, remember an advice that a juror gave me once. There's a big difference between inexpensive and cheap. So you want to make sure that you do things with value added, but make sure that you don't do something cheap. Because if you do that, whatever reason that you have for filing for an application, whether it's a provisional or something that down the line you're going to file into a non-provisional application, you're going to lose all of that value because it wasn't done properly. So I'll be more than happy to discuss all of this as much as possible, during break time. So any questions? We'll just go through these as we are asking for it. Does anyone have? Okay. I'm not sure how to stop this. I'll just click through this for the next presenter.
Any questions for Sudi? Tony.
There is an argument to say that patents cost a lot of money to put in place, and they cost so much to defend that sometimes it's worth not even doing it. What's your view on that?
It depends on your business model. If it is something that is first to market and is something that really you don't have any new idea, that is non-obvious and it's not new and it's all about how you're doing your business, although there's business method patents and a lot of people have made a lot of money on those, then you may decide not to file. However, if it's really something that is technology driven, and then you should be filing for a patent application. And just because it's not a physical prototype doesn't make it of any less value. But most investors do, for whatever reason, they do want to see a patent portfolio.
I understand there are some benefits between the US and Australia with the free trade agreement. Is there any advantages in having a patent filed in Australia in terms of simplifying or expediting the process in the US?
Again, it's jurisdictional. An Australian issued patent has no value in the United States by itself. However, you can take advantage of what they call the Paris Convention Treaty, PCT application. So if you file in your home country, whether your home country is US or Australia or anywhere else in the world which is mostly covered by PCT, you have 1 year within which to file the PCT application, and then you have 24 months after that before you make a final decision which countries, including US, you want to enter.
Hi. What is a patent-worthy idea? Is any algorithm that you have in your tool or anything that's technically a little bit challenging, what constitutes something that's worthy of a patent?
If it's going to make you money by excluding other people. You may decide to actually make your product and you want to prevent other people from taking it, and that's how you make your value proposition. Or you may actually decide, I'm not going to make this, or if it's a software or algorithm, I'm not going to actually do it myself, but I'm going to create a bag of assets, and I'm going to go ahead and license this, these assets that I have. So you don't necessarily have to be doing the company, operating, using those ideas. You can just license them, and then the strategy becomes very different because you have to worry about not infringing other people's patents if you're going to actually manufacture and sell and use those ideas you have.
Could you comment just on like a ballpark figure for the cost of issuing or filing for a patent in the U.S. as opposed to, say, international? I know it might be hard to say per country, but is it generally how much does it cost?
Okay, so there is a filing cost, and then there is what you call a prosecution cost. Usually a patent application might, in the U.S. alone, on the average, might take 2 to 5 years. There's all this initiative to make it faster, but nobody has seen that yet. In the U.S., if you're going to file for an application, you're talking a regular application, it's going to cost, let's say about anywhere from $7,000 to $12,000, $13,000 to file for something. And I give you a broad range because it depends on the complexity of what you have. Then how much it takes to prosecute it during that 2 to 5 year period depends how many times you have to go back and forth with the patent office. When you decide to file a PCT, that's again about $3,000 to $7,000 to file. Then after that whole 30-month period ends, if you decide to go to different countries, depends on if there's going to be a translation involved. India doesn't require a translation, for example. Australia doesn't require it, but China does. So it might take about $1,300, let's say, to enter the same thing into India, and then maybe about $5,000 China, different countries. But if you decide to go to some major countries, by the time you are done filing, you're not talking about just end result. This could be about $50,000, $70,000. So you have to make those decisions wisely early on.
Thank you. One more question.
If you've done your homework and research on the value potential of the IP, who should you consult with to potentially license it rather than to go into business?
Well, you do need to have advisors. I mean, none of us gets anywhere without having advisors. I've been doing this for 30 years, both technical and patent, and I have a lot of advisors. So you do need to be talking to people who have done it before, whether they're your attorneys, who do a lot of things other than just law, by the way. And also to people like the gentleman who just asked the question. I'm on the advisory board of Licensing Executive Society. We have a great network of people who can advise people whether they should manufacture, should they license, what are the considerations that they should make. But you definitely need advisors. Don't ever think that you can do it by yourself.
Super. Thank you, Stevie.
Thank you.
And finally, our last speaker for the panel.
Susan. There we are. This is right. You don't need to be too close up there.
Hello, good morning, everyone. How are you doing? I'm Susan Miraftabi. I'm a senior professional in human resources and a business HR manager at a medical device company currently. I want to give you an overview of what I'm going to be talking about today. Basically, if you're here to do business, you're going to want to know about how to hire local talent. And I want to also give you a basic on California and federal law from an employment standpoint and some tips on how to avoid legal pitfalls. Now, I get this information from studying about it, and we do have corporate lawyers and many lawyers I've worked on. So it definitely depends on you guys with this stuff, but I've learned and gained a few things or two myself over the years. So for hiring local talent as an HR manager, there's two things that I say that are important, and these are probably buzzwords, but we call employees talent. So you want to attract talent and you want to retain talent. So when you actually bring people to your company, you want to make sure you do everything you can to keep them. So the hiring process here is to advertise, source for resumes, And then you want to screen and select the best candidates. You can find more candidates through networking. I highly recommend staying on top of technology and using Facebook, LinkedIn, and also Twitter. And I can certainly answer any questions you may have about how to do that later. But at a high level, to me, whether you're on this side of the table hiring or you're on the other side of the table interviewing, networking is really important. Can everyone hear me? I'm hardly standing near the microphone. Does it sound good? Okay. And then interviewing for qualified candidates has some areas that I really want to focus on, because you can get yourself into hot water if you're not following California state laws and federal laws. Reference checking is something else we do here in America. Of course, people can give you their best friend's number so they could be their reference. No, there's a smarter way of doing this. You can ask them to give you their previous managers, people they've done business with, so they're not giving you friendly contacts, but actual professional contacts you can do reference checks on. But there are things you can or cannot ask during a reference checking process as well. And then for negotiating an offer and making an offer, you just have to follow a basic principle, but we can talk about, you know, the competitive salaries that are in the market, because that's how you want to make sure your offer is desirable for your candidates. And then for retaining talent, you want to definitely have a challenging work for them, and you need to put that throughout your advertisement. When you're interviewing them, you want to attract them by telling them what that challenging work is. I work with a lot of engineers and scientists, and for them, challenging work might be the latest and greatest bleeding edge technology, whether hardware or software that they're working on. You know, for someone else in another department, let's say marketing, it might be something else that attracts them. And then creating a healthy work environment is another way to retain employees. I'm going to be talking about that as well. So you're going to be doing business in California. You must know about at-will employment. This is an at-will state. Somebody like resonated that out there, so you know. Which means both parties can terminate this relationship, this employment relationship, with minimum notice, with or without cause. Now, employers must ensure that they don't violate this at-will by not advertising or making promises or interviewing candidates and making promises that say things like, this will be a secure position. You'll have a long-term commitment with this company. You'll never have to look for another job again. And I'm looking for someone to grow with the company. One of my employers made this mistake 30 years ago. They told someone they'd never have to look for employment again if they joined them. They're still paying his salary, even though he's no longer an employee, because they made that faulty promise. So the legal pitfalls to avoid. I'm going to focus on discrimination prevention quite a bit, because a lot of the lawsuits, and the lawyers can help me out here, although this may not be your specialty, discrimination and harassment and wage and hour laws get a lot of the lawsuits. So the protected statuses is what you don't want to discriminate against. Those are age, gender, race, color, religion, national origin, what country they're from, marital status, disability, and sexual orientation. Now, federal protects all of the above except sexual orientation. California protects sexual orientation. So it's unlawful to discriminate based on those protected classes that I talked about. And when you're making your business decisions, keep those in mind. Like I said, when you're making hiring decisions, any kind of employment application, you can't show bias towards females or 25-year-olds or whatever that might be. This should also show very properly and professionally in your interview process, job assignments, and of course I'll speak specifically to what kind of interview questions to ask or not to ask. Then this goes on to when they are actually on the job. Make sure you're not discriminating when you're promoting people, giving them merit increases, compensating them in any way, and also during the performance review and termination process. So here's something that would be near and dear to you, because right now you're trying to attract talent. interview for candidates. So when you prepare yourself for an interview, make sure you're pretty consistent with all candidates. And prepare interview questions that you will be asking similarly of all candidates. If you're interviewing for hardware engineers, know what specific qualities you're looking for in that candidate, and write those questions and ask the same of all candidates. You can also ask behavioral-based questions and try not to get into the yes or no questions, because that won't really teach you much about what this person is all about. But if you ask a behavioral question, that would be something like, tell me about a time where you had to work on a team and deliver something by a certain date and the deadline slipped. What did you do and how did you turn it around? So that would be an example of a behavioral question. And then you also want to ask appropriate questions so you're not discriminating. It has to be relevant to their work and the position. You don't want to ask about their hobbies or outside work activities. If that was a norm in your country, we don't do it here. And the reason for that is when you ask someone about what organization or clubs they belong to, you may be trying to figure out what race, religion, and so on they belong to, or maybe not. Your intentions might be pure, but the candidate may not see it that way. So stay away from these sticky situations. Don't even ask them about what languages do they speak unless it's part of the job's bona fide, I think that's how I say it, requirement. So if you really need a French translator, yes, you can ask, can you speak French? But if it's just a hardware engineer working here, it doesn't really matter what languages he speaks. As long as he can have good interpersonal skills or communication skills to work with his team, yes, you could interview about that. And again, let's remember, you don't want to overpromise. All right? So let's talk about workplace harassment. In this country, like I said, a lot of lawsuits, big lawsuits are about harassment. And usually people think about sexual harassment, but harassment is more than just sexual. It could just be a hostile work environment. You may, although you're a small company, but either a partner of yours or a manager of yours might be really harsh in his treatment of the employees and create a hostile work environment. So sexually oriented environment might be inappropriate jokes or posting vulgar pictures. It doesn't always have to be about touching another person. And it doesn't have to be male-female. It could be male to male or female to female too. You just don't want to create that environment for anyone. And it will have to be severe and pervasive. So it could be verbal, physical, and visual. And quid pro quo harassment, how many of you have heard that terminology? That just means this for that. So if, let's say you're a student and you are in a class and the professor says, if you go out with me, you'll get an A. So in other words, in an exchange of favor, if you go out with me, I'll give you an A. And a manager in a work environment, same thing. He might say, I'll give you a really good performance review if you go out with me. And that is definitely something that you could be sued against. Are you personally liable? Yes. Because if an employee comes to you and tells you they're in a hostile work environment or they're being harassed and you do nothing about it, you could be personally liable. You can also be personally liable if you engage in the sexual harassment or verbal harassment. Discriminate based on those protected classes I talked about. Retaliate after someone tells you they felt like they were being harassed by either moving them to another job or demoting them. Any kind of retaliation after someone makes a claim, even if it's a false claim, you could be held liable for. And also you can be liable for wrongful termination, which is something I'll briefly talk about. So the golden rule is to provide and maintain a dignified work environment free from all forms of discrimination, intimidation, harassment, or insult, for any reason, including but not limited to that based on race, sex, religion, color, national origin, disability, veteran status, sexual orientation, marital status, or any other reason prohibited by law. And then lawful termination, another golden rule here is to document everything. A lawyer's going to want to see what kind of documentation you have. And also have a really safe work environment. Even an employee may not like what he's hearing. Or if you have to terminate him, he may not like the fact that his employment's being terminated. If you treat that person with dignity, then the chances of you getting a lawsuit is a lot less. Unfortunately, being in Silicon Valley, I've had to do many reduction in force, which means laying off people. And even that, as upsetting as it is to both parties, myself, the manager, and the employee, I carry it in a dignified manner that people actually sometimes say, I'm sorry this didn't work out, but thank you so much for the opportunity. So no one goes away angry, wanting to file a lawsuit. So you treat people with dignity. Common sense, right? Any questions?
Perfect timing.
Because I can talk about this if we have more time, but otherwise I'll just leave it on so you can read it. Yes?
Asking a lot of questions today.
I can't hear you.
Is it appropriate to ask someone during the interview process about their immigration status? So we've been talking about immigration quite a lot.
I think if you just state it that way and you're not inferring about what country they're from, so you're saying, do you have immigration sponsorship? Do you have authorization to work in this country? You're just fine.
The common wisdom on that is you can say, because there is national origin discrimination, and if you ask somebody what their nationality is, even in a roundabout way, like if they're going to require visa sponsorship, it could get into a complaint, a discrimination complaint. So the common wisdom on that is to explain that at the time that they start work, they're going to have to show on the first day that they have lawful authorization to work in the United States. And that's code for them to say, I don't. So
that's good, thank you so much.
Yeah.
Thank you for that, it was very good. Could you please talk to us a little bit about hiring contractors versus employees and what we need to watch out for?
I can tell you a little bit, and I can certainly refer you for more information. Most of the times at our company, we have contingent workers that are temporaries from an agency. So the agency is the employer. So we got to make sure we don't cross, lines with that. Then there's the independent contractors, and their taxation and the whole way of their reporting is different. So an employee is on a W-2 for tax, a contractor is on a 1099, and a person from an agency might be a W-2 employee. And these are the forms for taxes. And so independent contractors aren't really your employees. They should be self-managed, but they may come and work for you, and they will perform services. But you should be treating them exactly like your employees. And for more information, I have a website on here. I don't know if you can see. I found that as a small business owner, when I was a small business owner, and later